Good afternoon, everyone. Thank you for joining John and I for our presentation on the different types of dispute resolutions available for construction disputes. For those of you who don't know, John and I are partners in the firm's Construction, Contracts, and Risk Management group. And in that role, he and I spend a good deal of time drafting and negotiating contracts for our clients. And the disputes clause in a contract is one of the top 10 provisions that we are usually reviewing to make sure that the called out process makes sense for the size of the client, the dispute, and the scope of work being performed. In order for you to make an informed decision about what alternative dispute resolution process works best for you, today we are going to cover what forms of dispute resolution are out there, how they differ from one another, and what the pros and cons are of using each form. Now, on a construction project, there are a number of issues that may rise to the level of a dispute. There are disputes associated with non-payment for contract funds, which can also develop into lien claims and bond claims and claims against prompt pay statutes. There can be disputes over project delays and the inefficiencies that develop. And there are also disputes over scope of work and change orders. Now, an important part of the disputes process is making sure that you first comply with all contractual precursors to pursuing ADR during the construction process. First, you want to make sure you are adhering to all notice requirements in the contract and letting the owner or contractor know of the issue while it's ongoing, because failing to do so can actually prejudice your right to have a dispute to resolve in the first place. You also want to make sure that you are following any claims process in the contract for resolution of a dispute. For instance, in the AIA form of agreement, they require you to submit a claim to the initial decision maker and receive a response prior to moving forward with any ADR process. In addition, in some of the custom form agreements, you're often going to find a requirement that the principals meet and confer on any dispute before proceeding to any other process.
Hey, Lisa, can I just add something on the first steps?
Sure.
So, it's very important to review your contracts and determine exactly what these steps are. I've seen everything from having 3 separate meetings before you even get to a mediation, where it's a meeting of the people on site, then a meeting of the project managers, then a meeting of the principals, all with different time constraints. As I've also seen, especially in government contracts, where there's a very convoluted board process, like the Department of General Services in Pennsylvania. And in fact, had one case in Baltimore County, Maryland, where the county itself was a party, the main defendant, and they were also the first judge of the case. So you had to try the entire case in front of a representative of the main defendant. So it can be all crazy things, and you have to make sure that they're followed correctly.
To John's point, only after you go through all of the initial steps that are outlined in the contract is your claim really ripe for dispute resolution. So what are the different types of ADR that are available for construction disputes? The 3 main processes really are mediation, arbitration, and litigation. And we're going to go through each one of those now. The first process that I'm going to talk about is mediation. So what is it exactly? Well, mediation is a resolution process where there's a third-party neutral that tries to help the disputing parties reach a mutually agreeable solution.
Hey, Lisa, I forgot to mention one thing. If anyone has any questions, they can type them into the question box on your screen, and Lisa and I will try to get to them as we go through the seminar. If we can't, we'll get to them at the end.
Yeah, and I apologize because I'm having a problem actually advancing the slides here on my end. So If there's any hesitation, it's because the slides aren't progressing as I wish they would. So here we go. All right, so let's talk about some of the key elements to mediation. First and foremost, it's non-binding. So that gives the parties the ability to basically come up with their own resolution or not. You don't actually have to commit to anything in a mediation if you don't feel that what's being offered to you is acceptable. The second key component is that mediation is confidential. And so that means that nothing that is said by either party can actually be used in any future dispute resolution process. Another element of mediation is that the parties actually share in the cost of the process. So the fees for any mediator that's selected, you each divide that up accordingly. And lastly, if the mediation is actually successful, typically neither side is going home happy. So you're not necessarily going to get everything that you wanted, but you've reached a resolution that puts finality to it and you can both move on. Okay, so here's an example of some contract language that discusses the mediation process and where the parties are committing to subject a dispute to mediation as a condition precedent to binding dispute resolution. Now keep in mind that even though you don't have specific language in your contract like this regarding mediation, you can voluntarily agree with the other side to mediate the dispute. And in addition, some federal courts actually often require an ADR requirement that the parties to litigation attempt to resolve their dispute with the assistance of a mediator or a magistrate judge. So just because your contract might not require mediation, again, the parties can ultimately agree. In terms of timing, under the AIA A201, as we discussed earlier, there needs to be an initial decision of a claim, and that's usually given by the initial decision maker, who oftentimes is called out as being the architect. And it can also be a condition precedent to arbitration or litigation, as the clause that we looked at just previously indicated. And really, you want to be thinking about whether it makes sense to be doing mediation pre or post discovery. Not all disputes are ripe for settlement early in a dispute. So if the contract requires mediation during the process, there's a substantial likelihood that the parties may not have sufficient materials or data to actually carefully and properly evaluate the claim. And even though the parties may hold off with mediation until the completion of the project, there still remains a high likelihood that the parties may not have learned enough about the dispute at the conclusion of the project. So if this is the case, or you already know the tenor of the discussions surrounding the dispute thus far, that an early resolution is going to be out of the question, you can always suggest that the parties either waive mediation as a condition precedent or postpone the mediation until it makes more sense, meaning that you take some discovery, maybe some depositions of some key project people, exchange some documentation, so you can get better up to speed on the positions of the parties. In terms of styles of mediation, there's really two different types. There's the facilitative mediation, and during that process, the mediator that you've selected is trying to reopen communication between the parties and explore what kind of options there might be for settlement, but the mediator is not going to openly express his or her own opinions on the issues, whereas in the evaluative mediation, the mediator is going to be asked to state his or her opinion on a particular issue. A frequent concern when approaching the mediation process is that the parties are often arriving with high expectations and a strong sense of legal certainty regarding the strengths of their own case. And so when that happens, you probably want someone that falls more in the evaluative category, because the mediator can help to adjust the other side's perceptions of his or her claims or defenses.
Lise, before you go on, with regard to an evaluative mediation, If you've never used that particular mediator before, it's always a good idea to tell them that you, one, don't want him or her to actually put a number on your case. I've had situations where the mediator has walked in and said, I think this case is worth about $100,000. Will you take that? And that was his first step at evaluating the case. That's not what evaluation means.
Basically, I just wanted to talk to you about the different, the whole process of mediation, if I could get to that slide. But to institute mediation, you really want to file a demand for mediation. And if you're using a forum like the AAA, they actually have a form for that. But if the contract doesn't require a specific mechanism, you can just simply demand mediation in writing to the other side. In terms of selecting the mediator, it can be done informally, where the parties actually can agree on an individual to perform the mediation and control the process on their own. But otherwise, mediation is done formally through a specific tribunal like JAMS or the American Arbitration Association. And when it's done formally like that, those tribunals will give you a list of proposed mediators based upon qualifications that you give them. And then you can kind of review them and strike off the ones that you're not interested in and rank the other ones, at which time the AAA will then spit out the name of who's been selected. We talked a little bit about having some kind of document exchange in mediation. It all depends on the complexity of the dispute. Obviously, if it's a simple case involving non-payment, you probably don't need to exchange a bunch of documents because the dispute is pretty narrow. But if it's a claim for delays and efficiencies or scope issues, it might make some sense to exchange some documents in the mediation process to better understand the other party's position. And then prior to the mediation, the mediator will typically require mediation statements. They can be confidential, meaning that they are only being sent to the mediator, or they can be exchanged between the parties. I have to tell you that in my experience, it's much better to have them exchanged among the parties because you kind of want to see where they're going in from the beginning. But that doesn't mean that you can't also have a confidential communication with the mediator that maybe discloses to them some of the hurdles that you see with the parties coming to a resolution. And then there's the mediation session itself. Typically, there are presentations or opening statements done. And in terms of that, the critical audience is actually your adversary, not the mediator. The mediator at that point has already reviewed all of the papers and understands the parties' positions. And then the mediator will have breakout rooms, essentially, where either side will go into a separate room and do what we call shuffle diplomacy, where they'll go back and forth talking to the different parties with respect to their positions. And then hopefully, ultimately, the mediation ends with a settlement agreement being reached. So to conclude, let's go through the pros and cons of mediation. In mediation, it allows the parties to express how they feel about a dispute and how they wish to resolve it. And the parties have the ability to consider practical solutions that a court may not be able to order, such as maybe the other side can't come up with enough money that's satisfactory to you, but maybe they're bidding on a great project and they're willing to give you a last look or something like that. That may be something that is appetizing to you that may help resolve the dispute, even though you're not getting an exchange of money necessarily to make you whole. It also helps continued and working relationships to be maintained. Oftentimes disputes arise between parties that do work together and over again. And so you don't want to burn your bridges. And so mediation helps you to keep those relationships solid. It also helps parties to see weaknesses in their case. The settlement terms are kept private and confidential, and the time and money can be saved out of court, and the process is certainly a lot more flexible than some of the other processes available. The cons to mediation is that there's really no winner and there's no final decision. It gives an opponent an early view of your strategy. So if the case doesn't settle, they obviously have a window into certain defenses that may be raised in an arbitration or litigation. You need a motivated opponent. If the other side's not motivated to getting it done, mediation's not going to work for the parties. And you need a mediator who confronts legal and factual issues. So with that, I'll turn it over to John, who's going to discuss the next process of arbitration.
Good afternoon, everybody. So it's always very interesting to me when somebody says, hey, I'm going to have a binding mediation. A binding mediation is a process that doesn't really exist because, as Lisa said, the idea is to go back and forth with the mediator in a shuttle diplomacy style to reach an agreement of a settlement. It is a settlement process. The next step is arbitration, which is binding in most situations. And arbitration is more like a courtroom experience in that you have a judge or judges, a panel of judges who render a binding decision about the dispute after receiving evidence and hearing arguments. So you basically go through the same process as you would in court, where the parties present their evidence, the witnesses are cross-examined and redirected, and the judge listens to, or the judge arbitrator listens to objections to questions. So it's similar to a courtroom process without a jury. So the key elements of an arbitration is that the arbitration panel or person has a position equal to a court judge, and that judge is chosen by the parties themselves. That person is supposed to be unbiased and renders a final and binding decision on the dispute after hearing both the parties and considering all the facts. The process of selecting that arbitrator includes them advising the parties what types of contacts they have had with all of the parties and their attorneys to avoid any appearance of bias. The arbitration is only available upon consent of both parties, and that is normally done through an arbitration agreement within your contract or subcontract. Absolute privacy is maintained in the process. It's supposed to be confidential, but once someone has to turn that arbitration decision into a judgment, it is no longer confidential and becomes part of public record. This is a portion of the contract language from the Standard American Arbitration Association contracts, AIA contracts. The AIA has a connection and has for probably 100 years with the American Arbitration Association. So whenever you see an AIA contract and arbitration is checked off, it's going to be through the American Arbitration Association unless it's been revised. And the arbitration agreement determines the key elements of the process. So you have to read them very carefully. One issue is how many people are going to be hearing the arbitration. If it's one arbitrator, you would be saving 77% in arbitration compensation, as opposed to having a panel of 3 arbitrators. The way it's set up under the AAA rules is that if a matter is in excess of $1 million, it's automatically 3 arbitrators, but your arbitration agreement can phrase it in any way that you wish. So sometimes it's automatically 1 arbitrator, sometimes it's automatically 3 arbitrators. The key here is to consider the cost as well as the desire to make sure that there's less of a possibility that that one person gets it wrong. How will the arbitrators be selected? Under the American Arbitration Association rules, you're given a list of potential arbitrators. You then check off any arbitrator who has a conflict that you know of, and you then rank the arbitrators. And once those are ranked, from 1 being the best to 10 being the one you really don't want to have, the other side does the same thing, and the AAA administrator will select the one with the lowest score. So if both people pick the same arbitrator as number 1, that's who you'll get as long as they have the ability to serve. Where the arbitration takes place is generally where the project is located. Now I've been seeing a number of different provisions where the contract itself says it's going to be where the owner's principal place of business is located, but understand that many states have statutes requiring any arbitration or litigation to take place in the state in which the project is located. The same issue comes up with the law that the arbitrators are going to apply. Basically, the statute I was just talking about also governs which law would apply, which is the law of the state in which the project is located. But the parties can jointly agree to have the arbitration really anywhere. If one party disputes that, though, that's when the issue arises. The next issue is, well, if it's not through the American Arbitration Association, who does administer the arbitration? More and more, we've been seeing that people are selecting their own arbitrator. So the 2 sides get together, they suggest some names, and given the fact that the construction bar, the number of attorneys that actually specialize in this area is small, they tend to find people that they can agree to and not do it through the AAA or JAMS in order to save some expense. The counter side to that is that there's more administrative requirements put on the parties and the arbitrator, but I've found that to work pretty successfully. As between AAA and JAMS, JAMS tends to have a greater amount of prior judges as opposed to prior construction attorneys. It does have construction attorneys, but the AAA is mostly construction attorneys and high-level contractors, principals, engineers, architects, etc. So in looking at which one you want to use, if your attorney thinks that having a judge with less construction experience but will apply the law is better, JAMS would be a better fit for your particular case. But it's done at the start of construction, so many times you don't know which to go with. I tend to move towards AAA with the right, if the parties mutually agree, to go to JAMS or an ad hoc selection where you selected yourself. As to who bears the burden of fees, generally the arbitration fees are split by the parties. Many times there will be an attorney's fee provision, which allows one side to ask for their attorney's fees if they're the prevailing or substantially prevailing parties. Sometimes those provisions also include arbitration costs, including the costs of the arbitrator compensation. You should make sure that it specifically expresses what you want covered in the event that you are successful.
John, if I could just jump in there real quick. Sorry.
Yeah, sure.
One thing I just wanted to point out with respect to the arbitration agreement as well is that it's very important that the language that is used for what claims are subject to arbitration is very specific. There are often disputes as to whether or not the arbitration language will govern your dispute. So you want to make sure it's carefully crafted to cover basically, any dispute with respect to the subcontract, whether, that include a breach, negligence, or whatever, so that you're not ending up having to fight about whether a dispute actually is subject to arbitration itself.
We also received a question on what types of things would conflict an arbitrator out of a case. It is cases where they've had a lot of contact with one attorney group or one law firm versus the other. We've seen situations where an arbitrator has tried 10 cases for a law firm in 5-6 months. That could be determined to be a cause for them not to sit on the case. I've had situations where the arbitrators have been, the proposed arbitrator have been suing or have sued in the past our client or the other side. Things of that nature. Anything that would throw a judge out would throw an arbitrator out. And also various issues like, are you friends with that person? What is the social connections? Things of that nature. All right, with that, let's go on to the next slide. So we received some statistics from the AAA as to how their process compares to a litigation process in front of a federal court. Every federal court is different. Some of them have what are called rocket dockets, but even a rocket docket is probably going to be like 9 months. But the average, according to the AAA, is 27.2 months from the filing of the complaint until the judge makes a decision. With the AAA, it's done in less than 8 months. I've seen some larger cases take longer, certainly not and every day you're in front of an arbitration panel situation for 8 months, it's more likely that the parties have just had problems of getting a schedule put together where everybody can participate at the same time. But it does go much quicker than a courtroom situation. One of the things that the AAA added a number of years ago is what's called fast track arbitration, which is something that I've actually served as an arbitrator for in a number of cases, and it's worked out very well. So if your case is for less than $100,000, from the day that you select your arbitrator, the entire case is done in 45 days. So basically, it takes about 15 days from when you file your demand to select the arbitrator. So you're going to be done in 2 most, and then have an award within 3 months of filing. So any case less than $100,000, I really like fast track arbitration, and it's also very inexpensive. You don't see this as much, but it's still out there. It is the pick one clause. Basically, the contract says that you will pick an arbitrator, the other side will pick an arbitrator, those 2 arbitrators get together and they pick a third arbitrator who will be the chairman of the arbitration panel. And then the arbitrators that were originally selected are called party arbitrators, and they are supposed to serve as the party's proponent on the panel and persuade the third arbitrator why their client is the right person and should win. Now, the problem with this is you're now paying for 3 lawyers to serve as arbitrators and 2 lawyers to serve as your lawyer, because one of them overlaps with those on the arbitration board. It to me is a monumental waste of money. You should be able to hire an attorney who has the ability to persuade the one arbitrator or the 3 independent arbitrators what is right and what is wrong, and you shouldn't need to spend the money on a proponent arbitrator. So I don't like these types of clauses, and I tend to strike them and modify them in a way so that the third arbitrator, the one that is supposed to be neutral, he or she is the only one who hears the case. So the 2 people that are picked by the parties are only there to pick the third party neutral. I've seen that work a few times. I've also been part of pick one arbitrations, and basically what happens is if the arbitrators all know each other, it becomes just paying for 3 arbitrators with nobody actually supporting anybody's position, everybody acting neutrally, and you've now wasted your money on 3 arbitrators rather than 1. So the process varies by rules. There's usually a demand for arbitration, and then the other side gets to submit a response. The arbitration demand is usually a page with some quick explanation as to what the case is about, as opposed to a complaint that you would have in litigation that could go on forever. Discovery is usually limited. tend to write into the contracts that each side will be able to have three depositions. But what happens is when during your first conference with the arbitrator or arbitration panel, you agree to some discovery, exchange of documents, and some depositions. Pre-arbitration motions, very rarely do they occur. If there's a very clear issue like a statute of limitations, the arbitrator will take that type of a motion, but outside of that, you don't see it happen very often, which again saves you some money. The arbitration statement is like a pretrial filing that will list all of your legal arguments and lay them out, as well as everything that your witnesses are going to say and the documents that you are going to present. The hearings, as I said earlier, don't necessarily happen all in a row. We try to have that happen as often as possible, but lawyers are just terrible estimators of time. And generally, when they say the arbitration is going to take 3 days, it takes 6. So you don't have them all at the same time. With the decision or award, as I said earlier, is final and binding. You would have to then take it to a court to turn into a judgment, which could act as any other judgment acts. The decision has to be given within 30 days of the closing of the hearings. There are arbitration alternatives. You don't see these much, but just so that you're aware of them, there's something called baseball arbitration. If you think of the arbitration that your favorite baseball team has with its players, one side decides on the number that they think the person is worth. The other side picks a higher or lower number, and the arbitrator has no choice but to select one of those two numbers. They can't go in between, they can't go higher or lower. It's got to be one of those two numbers. That's baseball arbitration. For non-binding arbitration, again, not a big fan of it, because now you are trying the case twice. You have a non-binding arbitration in front of an arbitrator. You're then going to court if you don't like what that arbitrator says, and you are now trying the case in front of a judge and possibly a jury. Again, very expensive. There is a new thing through the AAA, as well as JAMS, which is a Board of Appeals. If you so choose, you could write into your contracts, or if the parties mutually agree, there can be a right to appeal to a 3-person arbitration panel that are separate from the arbitrators that heard the case originally. Again, it kind of defeats the final and binding thought process of the arbitration, but people have been writing that in. Another alternative is what's called bracketed arbitration, similar to baseball arbitration, but everything in between the two numbers is available. So if one side picks $1 million and the other side picks 100, the arbitrator in a baseball arbitration has to give either $1 million or 100,000. Where in a bracketed arbitration, they can give anything between the $1 million and $100,000. And it allows the parties to cap their potential liability as well as their potential recovery. The pros and cons of arbitration. The selection of the arbitrator means the parties can agree to utilize someone who has expertise to understand the dispute. Remember that most judges try every kind of dispute that you could possibly think of, from the slip and fall to the medical malpractice to breach of a sales contract, to construction. Some have more than others, but most of them are not focused on construction like an arbitrator would be. You're getting a faster result. It can be less costly than litigation. The arbitration associations, though, are costly from the get-go. They require large filing fees, but the litigation in the long run, especially with a jury, can be significantly more in the long run. The arbitrator has more leeway to fashion a customized decision, and that always upsets me when I'm a party. I never want a customized decision from the arbitrator, but it does happen. And again, the decision, unlike a court, it's final. There's no right of appeal. Any ability to overturn is very difficult. You have to show fraud basically on the part of the arbitrator with the side that was victorious. So if a matter's complicated and the amount of money involved is modest, the arbitrator fee is still going to be a lot of money and may be uneconomical in that situation. The rules of evidence are very informal in an arbitration, and in that circumstance, it's a two-edged sword, because not only are you getting more evidence in which would normally be objected to in a courtroom situation, you have to remember that your opposition is also getting that right. So a lot of evidence comes in, and you hope that the arbitrators are smart enough to know which is good evidence and which is not. The other con, which can be controlled by agreement, is the limited right to appeal, as we've discussed previously. Lise, back to you on litigation.
Okay, so I'm going to discuss with you the last part of the available processes, which is litigation. As John said, arbitration does have some aspects of what a litigation is, but litigation as opposed to arbitration is a much more formal process through which one party attempts to enforce or defend its legal rights against another party in the lawsuit. Some of the key elements about litigation, it can either be a bench or a jury trial. If it's a bench trial, the ultimate decision maker is going to be the judge, and you have opportunities to present the court with argument throughout the process. Now, I will say that in certain jurisdictions, you're not necessarily with this judge the same through the entire process. You might have a different judge hear early motions, another judge might hear a summary judgment motion, and then there might be a final judge that's actually going to hear the dispute. That certainly happens out in Allegheny County where I am, but in Philadelphia County where John is, it's my understanding that you get assigned to a judge. With respect to a jury trial, the ultimate decision maker is going to be a jury, and it's going to be the first time that they're hearing evidence at the trial. So they're not involved in the entire process. They're just involved when you go to trial in the matter. So in terms of whether you want bench trial or jury trial, everyone's entitled to a jury trial unless the contract specifically indicates that the parties are waiving right to a jury. So if you're concerned, if your dispute, let's say, is against a city or a municipality and taxpayers are going to be sitting on that jury, you might want to consider having a waiver of a jury trial in your contract to make sure that you don't have taxpayers making decisions on your case. You can file in state or federal court. There are only certain instances where a complaint can be filed in federal court, such as if there's diversity jurisdiction, where you have to meet a threshold of amount for the dispute, and the parties have to be in residents of different states. But in any state court or federal court action, this is much different than arbitration. You actually have to prove every element of a cause of action to prevail. So where those elements are going to be, I'm sorry, let me just back up. Here's a section of, oh no, we're moving forward again. Here's a section of the contract, A401, which again allows the parties to select which dispute resolution process that they are agreeing to move forward with. But with respect to actually getting started with the litigation process, as John said, with arbitration, the demand for arbitration is usually a one-pager. It's just a summary of what the dispute is. But in litigation, you actually have to file a complaint, which is a very formal process where you have to lay out all of the facts concerning what happened, as well as set forth the legal basis for your claims, whether you have a claim for breach of contract and you need to make sure that you plead all of the necessary elements to set forth a cause of action for that. If it's a claim for negligence, the same thing. So you actually have to be very specific about the legal basis for the relief that you're seeking. Then once the complaint is filed, the complaint gets served upon the defendants, and that lets them know that they've been sued in a court of law. And then if you're on the receiving end of the complaint, the next, you have to file a response to the complaint, where again, in arbitration, sometimes people don't even do an answering statement. It's not required, but here you have to file a denial of any of the allegations, and you have to assert any defenses that you have. And with respect to certain defenses, if you don't raise them in your answer, they actually can be waived. And with respect to other parties that might have some liability for the claims that are being alleged in the complaint, you have the opportunity to bring cross claims, third-party claims, and if you also have claims against the filing party, you can bring counterclaims against them. Again, unlike arbitration, as John mentioned, it's very rare to have any pre-arbitration motions. Instead of answering a complaint in litigation, you have the option of filing a motion to dismiss, or in the case of Pennsylvania, they're called preliminary objections. And basically, you're taking a look at everything that's pled on the face of the complaint, and the defendant is arguing that the law basically says that regardless of what's pled, I'm still going to prevail. I have to tell you that it's a rarity actually to see a court dismiss a case at the very beginning stages, because there's often times many facts in dispute that need to be explored during discovery. So speaking of discovery, that's actually the next step in the process. This is basically how the parties are going to learn about each other's cases. In federal court, you make initial disclosures, and then there's formal written discovery that's exchanged, either document requests where you ask the other side for their various project records, interrogatories. is basically like a written deposition where you're asking specific questions to explore the factual foundation for the claims being made. You have the opportunity to file requests for admissions where you actually are asking the party to admit or deny a certain allegation. The point of doing that would be to set something up for a motion for summary judgment where you're trying to get the case dismissed. And then obviously the opportunity for depositions. Federal court, there's often a cap on the length of the depositions, the number of interrogatories or document requests, but for the most part, state court pretty much allows whatever the parties agree to. Obviously, if it becomes overly burdensome, there's opportunity to file motions with the court to try to limit the amount of discovery that a party is trying to take. And then once discovery is over, there are certain strategic maneuvers that you can make to get the case dismissed or to limit evidence. I mentioned that you can file a motion for summary judgment. So that's basically after all of the discovery, you're alleging that there is no legally relevant factual disputed issue. So there is no point in moving forward with the trial and the case should get dismissed. A motion in limine is basically trying to get evidence excluded or limited for purposes of it being presented at the trial. That gets filed as part of the pretrial preparation process. Then if all else fails and you haven't been able to get the case dismissed or a judgment in your favor, the case is going to proceed to trial. If you have a jury trial, it begins with jury selection. Otherwise, the court will start with opening statements where your attorney gets to, as the plaintiff or defendant gets to tell your side of things and what you intend to show during the trial process. Then there's direct and cross-examinations by both sides of all the witnesses that are presented, which are not only factual witnesses, but also, especially in cases of construction, you're going to have expert witnesses put on the stand to testify about your damages or your delay claim. Oftentimes there are objections raised by the other side to questions. And then you're going to do closing statements where your lawyers basically summarize all of the facts and the evidence that have been presented to the judge or the jury, and then a verdict or judgment is rendered. In terms of the pros to litigation, as you can see, it's a much stricter process. And, for some, it can be, validation to go through a litigation process to be the winner and get the full recovery that you're looking for. It also establishes precedent when a judge renders a decision on a certain legal issue that can often become binding on other courts and can be used in future litigation. It also can lend itself to settlement. I can't tell you on, one hand, maybe how many times I've actually gone to litigation because ultimately the case gets resolved on the courtroom steps before a trial even starts. And unlike arbitration, there are many more avenues to appealing an adverse decision that you don't like. And then the cons for litigation, it's certainly costly. Much more costly than arbitration. There's the longer time frame that John mentioned, and it's truly time consuming for your, business people and your employees to be pulled into all of these depositions, have to sit on the stand and give testimony. With respect to litigation, John had mentioned that in arbitration, he doesn't like arbitrators to get creative. Well, there is no creativity in litigation. The loser is going to get nothing. There's unpredictable results. And, that's often because, you might have some very good judges out there, but there are many others who just don't have experience in construction. and they cannot provide a fair or effective review of a dispute. But at the same time, a jury is often composed of people who don't want to be there and who have no clue what evidence is being shown or what is being said. And so, they might not understand all of the intricacies of construction in order to make a decision, that is based on fact as opposed to feeling. It can also be damaging to a party's relationship, and it's in a public forum. So, all your dirty laundry is aired out there. All the filings are a public record. Whereas in arbitration, again, those things are kept private. So that concludes our discussion on litigation.
A lot of owners are putting into their contracts are what are called choice clauses. And in those choice clauses, the owner gets to decide at the time of the dispute where it is going to be heard. They have the right to decide whether or not to mediate. They have the right to decide whether or not it should be an arbitration or litigation, one person panel versus three, or a jury versus non-jury. This can be very concerning because it gives the owner an unlimited ability to control the litigation. Since you always want to be the plaintiff, this could allow an owner, once they're sued in, say, arbitration, to make the decision it should be in litigation and file a suit in court to become the plaintiff as opposed to the defendant in the arbitration. Some courts will allow owners to get away with that. Some courts won't, and it becomes a crapshoot. So if you see a clause in one of your contracts with regard to owner or GC's choice of the forum for litigation, it's always a good idea to make them choose at the time of execution of the contract and not at the time of the dispute.
Just jumping in there real quick, one thing that I failed to mention is that there actually are certain claims that can only be pursued in litigation. So regardless of what the choice clause might be, if you have to file a lien claim, and most bond claims, those all need to be pursued in litigation and cannot be filed in arbitration.
With regard to the governing law, the law on construction changes from state to state. The jurisdiction could have a statute that says, for example, that you're not entitled to have no damage for delay clauses in your contract, where other states like New York specifically enforces no damage for delay clauses. So the jurisdiction whose law is being applied can have a major impact on your rights from the get-go. So if you get a dispute clause and your project is outside of the state that the contract says the law is going to govern, so for example, if the project's in New Jersey, but the contract says the law of New York will be applied, you may be at a significant disadvantage because New Jersey law is a lot more forgiving than New York law. So be careful of these clauses, make sure you review them and know which law is to be applied. With that said, I'm sorry we ran a little bit late. There was clearly some technical issues. Lisa and I would like to thank all of you for attending. We will be trying to have CCRM group seminars, webinars on a regular basis. Our goal has always been to have one a quarter and to give you any type of information with regard to contracts and your day-to-day claim issues that come up on projects. If you have any questions that we didn't address today, please feel free to shoot Lisa or I an email or give us a call. We would be happy to help you and respond to your questions as quickly as possible. In addition, if you have any thoughts on future seminars, please feel free to email Lisa or myself. Lisa, you want to say any parting comments?
Just thanks for attending.
All right, everybody have a great day and stay safe. Thank you.